Oh, thanks. Yeah. Where the wild things are.
Can you get her name?
This one is the charge. These two are fine, but I'm supposed to start too. You want me to show this? Is everybody ready to do it? Yes. Jail? Everybody ready there?
We are ready, Judge Rana. We can't hear you. Good.
The mic's not on there.
Which mic?
Right there in the front.
Oh, this,
Yep.
all these mics.
There you go.
Now can you hear me?
I can hear you. Just go
Okay,
ahead.
I'm gonna read the rights.
Okay, thank you.
Okay. Good morning, everybody. It is my duty to advise you of your constitutional rights. These instructions are important. Please listen carefully. Under the constitutions of the United States and state of Ohio, anyone charged with the commission of an offense is entitled to certain basic rights, which include the following. You have the right to know and understand the charges against you. You have the right to a speedy trial. You have the right to a trial by jury, or you may waive that right and have your case tried by a judge without a jury. At trial, the state of Ohio has the burden of proving you guilty by evidence beyond a reasonable doubt. You have the right to meet your accusers face to face and to cross-examine witnesses for the prosecution through your counsel. You have the right to summon and subpoena witnesses on your behalf, and you may not be compelled to testify against yourself. If you are unable to afford counsel, the court will assign counsel to represent you. You will be assessed a $25 fee for appointed counsel. You will not be denied an attorney if you are unable to pay that fee. At the end of your case, you may be ordered to pay the fee if your judge determines you are financially able. If you choose to hire your own attorney, you have the right to a reasonable continuance to hire one. You are not here today for the trial of your case. This is your arraignment, your opportunity to be informed of the charges against you, for bond to be set, and for you to enter a plea. You do not have to make any statement about the charges against you, but any statement may be used against you. As your name is called, please step forward. You will be asked when you received a copy of your indictment and whether or not you understand the charges placed against you. By law, you have 24 hours before you must respond to an indictment. If it has been less than 24 hours since you received it and you wish to continue the arraignment, you can waive the 24-hour notice and we will conclude. If your case is going forward by information, I will ask your attorney to place on the record that they discussed with you waiving the presentment of your case to the grand jury. You will be asked if you understand the charges against you, if you knowingly and willingly signed the waiver, if you consent that the charges proceed by information rather than by indictment, and if you wish to continue to be arraigned by waiving the 24-hour notice. You will be asked how you plead. A defendant may plead not guilty by reason of insanity, guilty or with the consent of the court, no contest. If you want to plead guilty and do not have a lawyer, or if you wish to enter any plea other than a not guilty plea, the court will assign counsel so you have the opportunity to discuss your constitutional rights before entering a plea. Your case will be assigned to a judge whether you plead guilty or not guilty. If you refuse to plead, the court will enter a not guilty plea on your behalf. If you have been charged with a crime of violence or any drug offense under Ohio law, you cannot knowingly have, carry, or use a firearm or a dangerous weapon until your case is finished. This is called being under disability. If you violate this disability, you could be charged with a separate felony offense in addition to the original charges. You are being arraigned today, and even if you have a permit to carry a gun, you are still under disability until the case is concluded. Upon indictment, the sheriff who issued the permit shall suspend your CCW license until your case is over. If you are over 18 and have not provided a DNA specimen since 2011, you may be required to submit one within 24 hours of arraignment. If you are placed on GPS electronic monitoring or TAD as a condition of bond, you will be required to follow all the rules and conditions. Specifically, any unapproved leave, late return, or being in an unauthorized location may result in warrantless arrest. Failing to properly charge or not charging the unit may result in warrantless arrest. Tampering or otherwise damaging your unit may result in warrantless arrest. You understand that you may be arrested without a warrant if you violate any bond condition or rule of GPS electronic monitoring. You must sign the GPS electronic monitoring rules, which will be explained to you prior to release as a condition of bond. When GPS electronic monitoring is ordered as a condition of bond, you will be asked by the judge if you were listening to the instructions regarding GPS, if you understand the rules allow you to be arrested without a warrant, and if you understand that you must knowingly, voluntarily, and willingly sign those rules prior to release. Pursuant to Ohio Revised Code Section 2937.99, if you do not appear in court as ordered after being released on bond, you may be charged with a felony of the 4th degree. Do you have anybody who wants to be here in person from the judge? Okay.
We'll start with a jail case number 692604, Bioca Ellis.
This has no family license.
Good morning, Your Honor. Ashlyn Carroll on behalf of Ms. Ellis. We would
Excuse
like.
me, I'm going to ask her the questions.
Oh, sure.
Miss Ellis? Miss Ellis? Miss Ellis?
Yeah,
Please raise your head.
where is it coming from?
I just need to ask you a few questions. I need to make sure you understand them. Do you have an attorney?
I'm looking for one.
Okay. Do you have the money or means to hire an attorney?
Repeat that?
Do you have the money or means to hire an attorney?
Possible.
Okay. Have you received and read your indictment?
I don't know.
You don't know if you've received it? Have you received it? Ma'am, just tell me whether or not you've received it, please. Miss Ellis, we'll be out of here in a few minutes if you just answer these questions.
You're
No, I haven't. Miss Ellis, have you received your indictment?
What was her name?
Ms. Ellis?
What was her name? The judge, what's the judge's name?
Russo,
Russo?
that's right.
Russo with an R?
Have you received and read your indictment? Yes or no? If you haven't received it, I'm going to send it over there. So you need to tell me that. Ms. Ellis? Why don't you want to answer these questions? All right, we'll come back to her when she's ready to talk to me.
Your Honor, could I just let the court know, our office does represent Ms. Ellis on another case, and
I understand.
there are some mental health issues, and I do believe they
I'll
have
come
been...
back to her.
Okay, just to clarify, I do believe she hasn't been on her
I will
medication.
come back to her.
Okay.
Come back in the courtroom, in counsel case 691911, co-defendant A, Mason Mora.
Miss Ellis? Miss Ellis,
Thank you.
have you received the indictment?
I don't know.
Would you like me to send it to you or read it out loud to you?
Thank you. Thank you.
That's not responsive. Would you like me to do either of those things? Miss Ellis? Do you understand on the indictment that the state has reserved the right to add the death penalty? Do you understand that? Have you read that?
ASAP.
What's ASAP?
What's video court?
Your Honor, we would like to enter a not guilty plea for Ms. Ellis. We would like to waive a reading of the charges, waive any defects in time or manner of service. As I said, our office has reached out to the jail to get mental health services for Ms. Ellis. They were working with her on a previous case, and our social worker has gotten involved. So we would like to ask that counsel be appointed and that the public defender's office be one of those two attorneys, and ask for a reasonable bond.
Has she received the indictment? Have you discussed it with her?
I personally have not, but I do know attorneys from my office did go see her last week, and that there were some notable mental health issues.
Did they go with the indictment?
That I don't know.
Well, then how am I expected to arraign her?
I would like to waive that time period for her.
This could be a capital murder case. I don't think that's appropriate. So if somebody wants to go over there now and go over it with her, I'll hold it. So send somebody over there.
I'll reach out to the office.
Okay, we'll come back.
In the courtroom, case number 691402, Shavonda McCrae.
Good morning.
Good morning, Your Honor. How are you today?
Good.
I'm filling in for Russ Cornball today. Unfortunately, Russ is still recovering from surgery. And Ms. McCrae has received the indictment and has waived the time and would like to enter a plea of not guilty at this point in time.
Okay. Ma'am, could you tell me your phone number, please?
216-926-1375.
I'm sorry, 12.
1375.
Okay, 13. Okay. $2,500 personal bond set. Judges John. You do? Do you have the money or means to hire an attorney? Have you received your indictment?
I don't.
Okay, have you read it? You have not read it?
I read
Okay.
it to you back there, right?
We have a copy here. You can read it.
I don't want to
You don't want to read it? Are you willing to accept that the public defender has read it to you? I'm sorry. You asked her not to. Well, but she did read it to you, correct?
No.
She didn't read it to you. Okay, well, we can read it in open court. Okay. It's a 10-count indictment. Count 1 alleges that on or about June 3rd, 2024, the defendant did purposely and with prior calculation and design cause the death of J.W. 10/29/2020. The state of Ohio reserves the right to seek a superseding indictment containing the appropriate 2929.04A aggravating circumstances specifications. And so you understand that means the state is reserving its right to add a death penalty specification. Count 2 alleges that on or about June 3rd, 2024, that the defendant did purposely cause the death of J.W. 10/29/2020. Count 3 alleges that on or about June 3rd, 2024, the defendant did cause the death of J.W., date of birth 10/29/2020, as a proximate result of the offender committing or attempting to commit an offense of violence that is a felony of the first or second degree, to wit, felonious assault, Ohio Revised Code Section 2903.11A1, and/or endangering children in violation of Ohio Revised Code Section 2919.22B2. Count 4 alleges that on or about June 3rd, 2024, the defendant did knowingly cause serious physical harm to J.W. on date of birth 10/29/2020. Count 5 alleges that on or about June 3rd, 2024, the defendant did torture or cruelly abuse J.W., date of birth 10/29/2020, a child under 18 years of age, and furthermore, the violation resulted in serious physical harm to J.W., date of birth 10/29/2020. Count 6 alleges that on or about June 3rd, 2024, the defendant did attempt to purposely cause the death of Margot Wood. Count 7 alleges that on or about June 3rd, 2024, the defendant did attempt to cause the death of Margot Wood as a proximate result of the offender committing or attempting to commit an offense of violence that is a felony of the first or second degree, to wit, felonious assault, Ohio Revised Code Section 2901.11A1. Count 8 alleges that on or about June 3rd, 2024, the defendant did knowingly cause serious physical harm to Margot Wood. Count 9 alleges that on or about June 3rd, 2024, the defendant did, knowing that an official proceeding or investigation was in progress or was about to be or likely to be instituted, alter, destroy, conceal, or remove any record, document, or thing with the purpose to impair its value or availability as evidence in such proceeding or investigation. Count 10 alleges that on or about June 3rd, 2024, the defendant did with purpose to deprive the owner, Volunteers of America store, of property or services, to wit, knives, knowingly obtain or exert control over either the property or services without the consent of the owner or the person authorized to give consent. I have now read the indictment to you. Do you wish to enter a plea of not guilty?
C.
Pardon me?
C.
What's same mean? Yes or no?
Yes.
Okay. I understand the victims are represented and they want to make a comment before I step on. Is that true?
Yes, Your Honor.
Okay.
Well, her mic is on.
Good morning, sir. Could you start with your name?
My name is Jared Wood, father of the deceased, husband of Margot. Your Honor, that day, 1 week ago, she took everything from us. There's nothing that could ever replace my son, or anything that my wife and I even our other kids are going through. It's horrendous. But I really wish no bail, period. Or extend it to the max limit possible that you can, at the very least. Just do whatever you can to keep this monster behind bars.
Thank you, sir. Is there anything else you would like to say?
That'll be it. Thank
Okay.
you, Your Honor.
Thank you. Is there anything else before I pronounce bond?
Your Honor, we would just ask that you consider assigning the Public Defender's Office, recognizing this is not our number. We did represent her at the first appearance unit. I did meet with her on Friday. We have had contact with her family and begun working on the case. Thank you, Your Honor.
When the original bond was set out of Muni Court, the bond was set at $1 million, and it was before the passing of one of the alleged victims. I do not believe that bond is appropriate given the change in circumstances and the allegations that are contained in this indictment. Bond is set at $5 million, cash, surety, or property. GPS, no contact with any surviving victim or victim's family, DNA order. Judge is John Russo, pretrial is June 17th at 9 a.m. I'll assign counsel.
Thank you, Your Honor.
Thank you, Your Honor.
You want me to sign it?
Thank you, Your Honor. Thanks for the save.